My name is Bill Gallagher with Superior School of Real Estate, and I'm very pleased to be with Jennifer Torres of the Torres Corporation. And
Great.
Jennifer has been helping us at Superior School educate and inform agents on some new RESPA rules, the Real Estate Settlement Procedure Act rules that became effective January 1, 2010.
That's correct.
Jennifer, what do we need to know about the RESPA changes?
Oh, what don't you need to know? It's huge. It's monstrous. It's probably one of the biggest reforms I've seen in 16 years. It is a huge rule that's relevant to the good faith estimate and the new HUD-1 settlement statement.
A good faith estimate.
The good
They
faith
call
estimate.
the GFE.
GFE.
And a closing statement they call a HUD-1. Wow, what's happening with the good faith estimate?
Well, with the good faith estimate, it used to be that you would have 6, 7, 8, 9 different versions of it depending on the lending institution, the state. It doesn't
Different
matter.
lenders had different
Absolutely.
forms.
Yeah, and the other problem with it was no one was held accountable.
What? Wow.
Yeah, nobody was guaranteeing the paper that it was written on. Now they are. Now lenders are bound to the fees of which they quote. There's a zero tolerance section and a 10% tolerance section.
Let me ask you this question, Jennifer. The borrower gets the good faith estimate at loan application.
Correct.
Well, isn't it sometimes normal that fees change between loan application and the closing?
It can, absolutely
Okay.
it can. Things that could change are a qualified change circumstance. An example being that they thought they were going to go conventional, it turns out they have to go FHA.
Oh, okay.
And then a lender is permitted to change the fees that were affected by the change circumstance, but only the fees that were affected by the change
Okay,
circumstance.
very good.
So meaning that's not the time to revise attorney's fees or recording fees because those aren't relevant to whether they went FHA or they went conventional.
Okay.
So it binds them to what they quote from the beginning with a little bit of wiggle room based off of if there's a qualified change circumstance.
Well, Jennifer, I know how borrowers want to shop, lender to lender to lender. So what you're saying is the borrower needs to have a good faith estimate from the lender in order to compare.
Absolutely. That's the goal of the good faith. The goal of the good faith is to compare lender to lender, fees to fees, loan to loan, so that they can, in essence, make the best decision that they want that works for them.
And then when they get to closing, there's no surprises.
Correct.
Well, Jennifer, let's say we get to closing and some fees have changed. What are the consequences?
Well, now there are actually consequences, whereas before there weren't. If a lender violates the zero tolerance section or the 10% tolerance section, they have to cure it, meaning they have to write the borrower a check and or put it on the closing statement or cure it at least within 30 days of closing.
Jennifer, it sounds like there's so many changes that have come down, and as real estate agents, we need to know about these changes. You are now teaching a course at Superior regarding these changes?
Absolutely.
And what's the name of the
Honored.
course?
It is Understanding the New HUD-1 and Good Faith Estimate.
And it's a 4-hour
It is a
approved
4-hour.
CE elective course by the Real Estate Commission. And what do you discuss in the course?
We discuss everything. That's the goal.
Okay.
Is to make sure that agents completely understand the good faith. Agents before weren't really involved in the good faith estimate. Well, now with there being consequences, that's the best representation of their consumer to make sure that they do understand it. Now, the new HUD-1 settlement statement is at minimum 3 pages, but we've seen it get upwards of 6, 7, even
3
8
to 6
pages.
to 8 pages HUD.
Yes.
Wow, we need to be aware of.
You need to understand it and be able to go over it with your client and know what to expect. It's a very, very vital process to the entire closing, and you need to make sure that your client is understanding everything that they're getting. If you don't at least feel comfortable advising your client, you know where to get the information.
And also, the real estate agent in North Carolina is held accountable to the accuracy and delivery of the closing statement. So
They are.
that is definitely needs to be on our to-do list to understand that statement. So do you teach the good faith estimate?
We do. We teach the good faith estimate. We give samples of both,
Okay.
with tolerance violations, without, so that they can completely see what procedure would be taking place if something was violated. Also making them very, very comfortable in answering every question that we can with regards to these federal
Okay,
changes.
very good.
There is a lot of opportunity out there for delaying closings, potentially 3 or 6 days, even if you don't know what you're looking for or what could potentially come up. And the last thing any of us want is delaying a closing 3 to 6 days.
Exactly, in this kind of market too. Jennifer, thank you for being with me
Thank
in
you for
Superior
having
School of
me.
Real Estate, and I hope that you will consider taking Jennifer's course, the new Good Faith Estimate, the new HUD-1 Closing Statement, which is a 4-hour CE elective course approved by the North Carolina Real Estate Commission.